Let me now introduce our first speaker. Professor Chie Kojima is Professor of International Law at the Faculty of Law, Chuo University in Tokyo. She holds a PhD in law from Chuo University and an LLM and a JSD from Yale. Her recent research interests include protection of the marine environment, maritime security, and human rights at sea. She's on the editorial board of Ocean Development and International Law, the Asia-Pacific Journal of Ocean Law and Policy, and the Law and Practice of International Courts and Tribunals. Chie, over to you.
Good morning and afternoon, everyone. I'm Chie Kojima, Professor of International Law at Chuo University in Japan. It's a great pleasure to join this workshop from Tokyo today. I would like to thank the organizers for giving me this great opportunity to discuss pressing ocean matters despite the COVID-19 pandemic. The title of my presentation is Towards Global MSR Governance in the Era of Climate Change. Okay, sorry, it goes too fast. So this is the outline of my presentation today. First, I'll be discussing why marine scientific research, MSR, is important in tackling adverse effects of climate change on the marine environment by clarifying the goals in light of current situations. I'll be briefly referring to where knowledge gaps exist in taking mitigation and adaptation measures against climate change. I will also touch upon issues related to new technologies in MSR that have been tested or in use, such as marine climate engineering or geoengineering. I will then discuss challenges of the UNCLOS regime on MSR, namely the zonal approach and informal strategies existing outside UNCLOS as efforts to improve global MSR governance, and finally move to the conclusion. The IPCC special report on the ocean and cyclosphere in a changing climate, published in 2019, confirms that carbon emissions from human activities are causing ocean warming, acidification, and oxygen loss. The ocean warming in particular caused much stress on marine organisms, ranging from phytoplankton to marine mammals, and contributed to changes in their biogeography and community composition. The report warns that by the 22nd century, the ocean is very likely to warm by 2 to 4 times as much for low emission scenario and 5 to 7 times as much for the high emission scenario compared with the observed changes since 1970. Shifting distributions of fish stocks due to climate change is already obvious in many regions of the world, which will not only increase the risk of potential conflicts over fisheries among states, but also endanger economic security of fisheries-dependent communities, as well as food security of future generations. In order to prevent and minimize adverse effects of climate change on the marine environment, a variety of ocean-based mitigation and adaptation measures have been discussed and actually implemented to a limited extent. The IPCC report points to the fact that uncertainties and gaps exist as to the effectiveness of these measures, in particular, ecosystem-based adaptation measures such as restoration of coral reef. A number of measures are still at the proof of concept stage and requires further scientific research. Taking adaptation measures in fisheries as an example, the IPCC report states that 60% of assessed species are projected to be at high risk from both overfishing and climate change by 2050. Changing distribution of fish stocks across maritime boundaries increase the demand for effective transboundary fisheries management. In addition, integrated coastal management and MPAs have emerged as important adaptation responses in fisheries, as well as marine ecosystems. Effective fisheries governance supported by these measures depend heavily on data collection and monitoring systems. The IPCC reports that knowledge gaps in evaluating adaptation measures in fisheries. Furthermore, how climate change will affect the deep oceans and its fisheries is still unknown. I would also like to highlight technological innovations that have been used to advance MSR in understanding and counteracting adverse effects of climate change to the oceans. Since the early 21st century, thousands of autonomous profiling floats called algo floats have been deployed in the world ocean for collecting temperature, salinity, and pressure profiles of the oceans. Those floats drift with the ocean currents and move up and down between the surface and the mid-water level. These floats are usually not fixed, but they have to be fixed by cable on platforms if deployed on ice-covered waters. Marine climate engineering, such as ocean iron fertilization and ocean upwelling, are also new technologies that have been invented to counteract climate change. They are not only of transboundary and potentially global characters, but also human interventions to the climate systems whose potential negative impacts on the marine environment are unknown. So how could the UNCLOS regime accommodate the need to advance MSR in relation to climate change? From a historical point of view, MSR was not a concern for international regulation, and MSR activities were controlled under sovereignty. The need to regulate MSR arose from the time when states started to claim their sovereign rights over their continental shelf and explore and exploit more resources in the oceans. In promoting the study, protection, and preservation of the marine environment, as it referred in its preamble, the convention provides for the first time in the multilateral treaty the right to MSR enjoyed by all states and international organizations. The convention takes the zonal approach and balances the interests of researching states and coastal states by creating the consent regime for MSR conducted within areas of national jurisdiction. Coastal states can exercise its jurisdiction to regulate, authorize, and conduct an MSR within the territorial sea, the EEZ, and the continental shelf. UNCLOS also provides freedom of MSR on the high seas as well as the right to conduct MSR in the area, which should be exercised exclusively for peaceful purposes and for the benefit of humankind as a whole. The consent regime seems to be straightforward, but the UNCLOS regime is facing challenges in meeting the need to advance MSR globally across maritime boundaries and using new technologies in the era of climate change. First, the lack of definition of MSR creates uncertainty about the applicability of the UNCLOS rules to a wide range of research activities related to the mitigation and adaptation measures in climate change. Taking the algo floats as an example, while researching states considered algo floats as operational oceanography and thus not covered by the consent regime under Part 13 of UNCLOS, a number of coastal states viewed operational oceanography as a modality of MSR under UNCLOS. Second, there are no explicit references to competent international organizations which have the right to conduct MSR. It is generally understood that this phrase means only intergovernmental organizations, but it has been widely recognized that a number of non-governmental organizations, including professional societies and research institutions, are formally or informally involved in MSR activities in tackling climate change. Third, the consent regime for MSR in the EEZ is unevenly interpreted by the international community. In applying the regime, some coastal states apply more stringent rules on MSR than other states. Fourth, disputes arising from MSR in the EEZ and continental shelf are not subject to compulsory dispute settlement system under UNCLOS. Fifth, it is unlikely that apart from the consent regime, the rules concerning MSR under UNCLOS become customary international law due to the lack of state practice in MSR. Active participants in MSR are mostly developed states, and there are little practice from landlocked or geographically disadvantaged states. Different interpretations as to the consent regime could derive from the text of UNCLOS. Article 246 stipulates that coastal states should give consent in normal circumstances for MSR projects conducted exclusively for peaceful purposes and in order to increase scientific knowledge of the marine environment for the benefit of all mankind. At the same time, the article provides that coastal states may withhold their consent if the project is of direct significance for the exploration and exploitation of natural resources, whether living or non-living, or if it involves the construction, operation, or use of artificial islands, installations, and structures referred to in Articles 60 and 80. These rules leave a room for various interpretations and may be used as a trump card for coastal states. While there are many challenges in the UNCLOS regime, the duty to cooperate in MSR stipulated under Article 200 plays an important role. The duty to cooperate is recognized as a fundamental principle for the protection of the marine environment, and UNCLOS creates a linkage between MSR and the protection of the marine environment through the duty to cooperate. As a framework of agreement, UNCLOS doesn't specify means for cooperation, and the implementation of the duty to cooperate may rely on formal or informal processes. The duty to cooperate in MSR exists in other international environmental conventions, such as those listed on this slide. The last but not least important point is that international organizations are playing an important role in improving global MSR governance beyond UNCLOS. By informal strategies, I mean not only soft law instruments, but also various actions taken across different actors in the process of achieving a common goal. As one of such strategies, I would like to highlight that this year marks the first year of the UN Decade of Ocean Science for Sustainable Development. Other efforts include the Global Ocean Observing System established by the Intergovernmental Oceanographic Commission, IOC, of UNESCO. Of UNESCO. This system is a successful example of gathering resources of the member states and letting their expert stakeholders to participate in a global research project like algal floats. The ISA also facilitates international cooperation for MSR in the area. Recently, the ISA launched the Deep Data, which gathers all deep seabed related data submitted and collected by contractors through their exploration activities for sharing purposes. The ISA developed the draft action plan on marine scientific research in 2020 with a view to implement the UN Decade of Ocean Science for Sustainable Development. There are many other action plans that are being developed in different regions and themes at the moment. So in conclusion, we need alternatives to the MSR regime under UNCLOS to facilitate the process of gathering accurate scientific information, that are necessary to take appropriate measures against climate change. From such perspective, informal strategies offered by some international organizations help improve global MSR governance beyond the consent regime under UNCLOS. However, UNCLOS and informal strategies do not necessarily conflict with each other, in my opinion. The duty to cooperate in UNCLOS can serve as a tool for developing global MSR governance for the protection of the marine environment. Thank you very much.
Thank you, Professor Kojima, and thank you for your patience with the small technical issues at the beginning also. Very good. Now I'd like to introduce Professor Karen Scott. Professor Scott is at the University of Canterbury in New Zealand. She's the president of the Australian and New Zealand Society of International Law. She's also editor-in-chief of Ocean Development and International Law, and she teaches and researches in law of the sea, international environmental law, polar law, and policy. Karen.
Tēnā koutou, thank you very much, and kia ora, Caroline, for that kind introduction. I hope everybody can see me. I'd just like to begin by thanking the organisers for their kind invitation to contribute to this excellent workshop, and in particular to this panel. I'm now going to try and share my screen. I can share that one, just bear with me, thank you. Play from the start, there we go. So the title of my presentation today is A Line in the Sand, Fixing Maritime Boundaries for Pacific Island Nations. I think contemplating the question of climate change in the Pacific, one immediately is drawn to the issue of maritime boundaries, maritime zones, and the impact of sea level rise on those zones. Chie set out a wonderful overview of the impact of climate change on the oceans, and the particular issue that I'm interested in is sea level rise. And of course, it is predicted that sea level rise may increase by a metre or indeed more by 2100. And whilst this is a global consequence of climate change, it is a consequence that is likely to have a disproportionate impact, at least in the short to medium term, in the Pacific. And of course, that is because we have a number of low-lying island atoll states which are at risk of inundation, or at least very significant disruption. So what I want to do in this paper is explore the question of fixing maritime baselines and or outer limits, which has been proposed by a number of commentators and indeed organisations. But in particular, I want to focus on two potential regional mechanisms, which I've described as imperfect but potentially pragmatic, as options really to try to move this area of law forward. So in terms of sea level rise, as I say, it's predicted that about a metre of sea level rise, and that's now considered to be quite a conservative estimate, may occur depending on the climate change scenario. And the level of sea level rise isn't consistent across the globe. And in fact, in parts of the Pacific, particularly the Western Pacific, sea level is rising at a much faster degree than it is elsewhere. In terms of the impact, there are of course many impacts that sea level rise will have on both the environment and peoples in the Pacific, but confining it to the issue of maritime zones and maritime delimitation, the physical consequence of sea level rise is typically that the normal baseline, that is the low waterline, is often forced landward as coastal erosion occurs. And base points such as islands, rocks, reefs, etc. may well be lost, also impacting on the size of maritime zones. And of course, in the most extreme scenario, maritime zones may disappear altogether if the land disappears, really following the consequence of the broad principle of the land dominates the sea. That is, maritime zones are associated with territory. So if that's the physical problem, the legal problem is that the consensus really of most commentators, and indeed the International Law Association in 2 reports, one on baselines and one on sea level rise, is that baselines are ambulatory. That is to say, they move with the coast, they follow the coast, they follow the physical geography of the coastline. So to the extent that that physical geography changes as a consequence of sea level rise, then this will have consequent implications for those maritime zones. And whilst it is not stated in UNCLOS that baselines are ambulatory, this is a reasonable interpretation given the broader context of UNCLOS and the fact that UNCLOS does in fact identify a couple of situations where limits are in fact not ambulatory, that is where they are fixed. So those 2 situations being under Article 7.2, you can use straight straight baselines in the context of deltas and other natural conditions where the coastline is highly unstable, and those straight baselines will remain even in the context of coastal shift. The use of the word "and" in Article 7.2 does suggest that this provision is in fact limited to deltas as opposed to broader situations where you have an unstable coastline. The other situation where your outer boundaries are fixed is of course in relation to the outer continental shelf. So where your continental shelf beyonds 200 nautical miles and limits are established on the basis of the recommendations of the Continental Shelf Commission, and these are considered to be final and binding. A third situation, which relates to fixed boundaries, is in the context of agreed maritime delimitations, where there are treaties which establish maritime boundaries between states. And here the relevant provision is Article 62.2a of the Vienna Convention on the Law of Treaties, which essentially excludes boundary treaties from being set aside as a consequence of unforeseen circumstances. There is a debate in the literature as to whether those boundary treaties apply simply to territorial boundaries or whether they are broad enough to also apply to maritime boundaries, and the consensus seems to be emerging that it does apply to maritime boundaries. So if that's the legal problem, there is a fairly straightforward legal solution in that you should be able to fix boundaries. So potentially you're fixing your baselines from which you measure your boundaries, or you fix your outer limits, or you potentially fix both. And there are slight different consequences depending on what is fixed in terms of your actual maritime zone. So this is a proposal which a number of states have indicated some support for, and it was also supported by the International Law Association Committee on International Law and Sea Level Rise, which reported in 2018 in Sydney. And they essentially says that states should accept that once their baselines and the outer limits of their maritime zones of a coastal state or an archipelagic state have been properly determined in accordance with the detailed requirements of UNCLOS, then these baselines and limits should not be required to be recalculated should sea level change affect the geographical reality of the coastline. So assuming you establish your baselines, your outer limits on the appropriate provisions within UNCLOS, then they should remain, notwithstanding sea level rise. And I think thinking about sort of justifying this approach, even though it is not expressly stated under UNCLOS, and indeed the convention would support an ambulatory approach, there are actually a number of different bases to support fixed baselines, including equity or fairness as between states, stability of the regime, transparency, and you can also actually use it to support states' obligations with respect to adaptation under the climate change regime. So I think there are a strong argument supporting fixed baselines. In terms of how you might go about it, this is something which commentators have been thinking about for about the last 30 years. So really at the very early stages of sort of the issue of sort of climate and the oceans. And there's been a whole range of measures. In the sort of a brief survey of the literature, I pulled out sort of 10 broad types of solutions or mechanisms which authors have suggested in the past. And these really range from physical measures, such as those actually reinforcing the coastline or building up islands, to the more technical legal measures, such as depositing a chart with fixed coordinates, interpreting UNCLOS in light of subsequent practice, potentially developing a general customary norm, recognising historic rights, through to actually adopting separate instruments. And these might include instruments under the climate change regime, such as a protocol to the UNFCCC, or instruments associated with UNCLOS itself. So potentially a decision of the parties to UNCLOS, an amendment to UNCLOS, or an agreement on sea level rise, or possibly an external measurement or instrument such as a UN General Assembly resolution. So there are a range of different options which have advantages and disadvantages, and certainly nothing has been settled on as yet. So assuming that these are sort of 10 which have been identified, what I want to do in this paper is just very briefly put forward options in 11 and 12, if you like, 2 further options, which focus on a regional approach to fixing maritime zones. And I've described these as sort of imperfect but pragmatic question mark, and I'd be interested in feedback as to whether they are very imperfect or not sufficiently pragmatic. Imperfect, I think, because in an ideal world, principles of the law of the sea should really be decided on a global basis, and that there are inevitable challenges in developing a regional approach. But pragmatic, because as we shall see, there has been quite significant regional practice in the Pacific in this area, and there appears to be a groundswell of support for this approach, and potentially taking steps within the Pacific may well be considered to be a first step to a more global solution. So the 2 options that I'm suggesting here today are first a modification of UNCLOS pursuant to Article 311 paragraph 3 and of course Article 41 of the Vienna Convention. So that is essentially an agreement as between Pacific Island states. And secondly, alternatively, or potentially in cumulation, recognising a regional customary norm applicable to Pacific Island states supporting fixed maritime boundaries. So why essentially take a regional approach? Well, I think the first argument is that there has been significant practice within this region, quite understandably, given the nature of the threats, both at the regional and at the national level. So there is essentially a groundswell of support of instruments of practice which indicate a movement towards fixing maritime boundaries, maritime zones on the basis of fixed points, notwithstanding sea level rise. So just on the slides there, 3 examples of instruments which have been adopted regionally over the last decade or so, which basically support the idea of taking efforts or taking steps to fix maritime zones which cannot be challenged due to sea level rise, using the language of the Framework for a Pacific Oceanscape. The 2015 Declaration on Climate Change, which came out of the Polynesian leaders groups, talked about essentially calculating maritime zones according to emerged lands and permanently establishing baselines in accordance with UNCLOS without taking into account sea level rise. And similarly, the 2018 DLAP commitment, which was adopted by the 8 parties to the narrow agreement, agreed to pursue legal recognition of defined baselines, again established under UNCLOS, to remain in perpetuity, irrespective of the impacts of sea level rise. At the national level, a number of states in the Pacific, supported, I think it's worth noting, by other states, including New Zealand and Australia, have been developing maritime legislation, which effectively establishes fixed limits, a number of which are expressly said to be fixed in the face of climate change. So far this includes the Marshall Islands, Cook Islands, Fiji, Kiribati, Nauru, Niue, Palau and Tuvalu. So there's quite a significant sort of national practice in this area. So how might sort of these options work? Well, option 11, which is a modification agreement, really builds on the opportunities for a group of states to modify a treaty as between themselves under certain conditions. So generally, modifications of treaties is permitted under Article 41 of the Vienna Convention on the Law of Treaties. And I've put the text up there. So essentially a modification agreement can occur between two or more parties, as long as the option is provided for by the treaty or it is not prohibited by the treaty. And it does not affect the enjoyment of the treaty by the other parties, and does not relate to a provision derogation from which is incompatible with the effective execution of the object and purpose of the treaty as a whole. UNCLOS itself provides for modification under Article 311, so essentially allows parties to conclude agreements modifying or suspending the operations of UNCLOS, applicable solely to relations between them, and then essentially sets out the same conditions, or broadly the same conditions, as under the Vienna Convention. So thinking about a possible Pacific sea level rise modification agreement as between those Pacific agreements. With respect to those four conditions, I think the first two can be quite easily met. The agreement, I think, would not relate to a provision which is essential to the object and purpose of UNCLOS, and would not affect the application of the basic principles. The third requirement, I think, maybe could be challenged in theory. Of course, if you are fixing maritime zones and therefore not allowing the maritime zones to revert to the high seas, which potentially they would in the Pacific, one could at least argue that that might have an impact on third states. So there is a question mark there, but one would hope not. But the final problem, I guess, is that the agreement would only be applicable solely to the relations between the parties to that agreement. So essentially to the Pacific nations themselves. And that is potentially problematic because you would actually want something which is applicable to all parties. Now I see I'm almost out of time, so I'm just going to say a few words on the sort of final options. I've just put on the slide there some of the advantages of this, in the sense that it's a much quicker process in contrast to the amendment, and other states can potentially support this process by simply coming out and actually supporting that process. The other option, in the final few seconds available to me, is potentially evolving a specific or regional custom in the Pacific. Now, I think there's no reason in principle as to why you could not develop such a regional custom, setting out fixed maritime zones for the Pacific. And indeed, the International Law Association Committee indicated that there was a significant body of practice which was beginning to develop custom in the region. Of course, again, the one problem that we have with a regional custom is whether it is opposable to states more generally. That goes to the imperfect part of this particular proposal. But again, I think that could be addressed where other states actually accept or acquiesce that custom. So I will leave the future steps up there for you to peruse, since I am out of time, and would just like to say thank you very much, and I look forward to the questions and discussion.
Kia ora, Karen, thank you very much. And now I'd like to introduce Dr. Bjørn-Oliver Magsig, who is a senior lecturer here at the Faculty of Law at Victoria University of Wellington. He focuses on the law of freshwater resources, climate change, and the marine environment. He's led various interdisciplinary projects on the management of transboundary natural resources, and he serves on the managing board of the Journal of European Environmental Law, the European Environmental Law Forum, and also is a member of the IUCN World Commission on Environmental Law. Bjørn-Oliver.
Tēnā koutou. Thanks, Caroline, for the kind introduction. What I'm trying to do with my presentation today is build on what my excellent co-panelists have already done, the Ocean Climate Nexus, and have a look at how international law is managing this nexus, whether it's doing a good job, whether it's doing an effective job, whether it actually is a legal problem. And I don't have to go into too much detail about the actual nexus. You've just heard two excellent presentations talking about sea level rise and other issues. But yes, we have to remind ourselves that the ocean system and the climate system are very closely interlinked, that the ocean is the biggest carbon sink, that it has absorbed around 90% of the excess heat of global warming. So without this carbon sink, it would look a lot worse. And of course, ocean acidification, Karen has written on it as well. A huge problem when we talk about coral reefs, the so-called osteoporosis of coral reefs. And as many of you might know, the coral reefs are hugely important when we talk about marine biodiversity. A lot of species need the coral reefs intact to not be extinct in the near future. We also know that a lot of the climate records are being broken on a yearly basis. On a monthly basis, sometimes you read that we have a new record, and the same is sadly also true for the marine environment, for the ocean, because of course it is linked. So we see more ocean heat waves. The oceans are heating up a lot faster than initially thought by the scientists, which brings us to this very intricate relationship between law and science, which I'm sure will come up in the discussion as well. So as I said, what I'm trying to do in the next few minutes, and then in the discussion afterwards, is look at this ocean climate nexus and analyze how well those regimes, UNCLOS and UNFCCC and Paris, in terms of the climate regime, are addressing this interlinked twinned crises, as it's been called as well. So the idea, of course, is you want this intersection in the middle to be as big as possible. What you definitely don't want is the two regimes operating in a way which makes it smaller, which probably even goes against the other regime. So thoughts about fragmentation come up, regime interaction, all those issues. And my main question is it actually a legal problem? How well is the international legal system equipped to deal with the ocean climate nexus by focusing on those two regimes? So let's start by looking at UNCLOS. We know that in Part 12, which covers the marine environment, there is this very general obligation that states have to protect and preserve the marine environment, full stop. UNCLOS goes on in 194 that states shall take all measures to prevent, reduce, and control pollution from any source. The same article reiterates that point by saying that measures shall be taken with all sources of pollution in mind. So it's not a purely marine environmental agreement. So there are potential indications for cross-fertilization. It then, in section 5, continues to say, well, special care, of course, should be taken to rare and fragile ecosystems, endangered species, and by just looking at ocean acidification, it becomes very obvious that that would be one of those cases where we need to do better to protect the coral reefs, for example. You might ask whether carbon emissions are actually considered pollution. And if you look at the definition of pollution in Article 1, you would have to say yes, because it says that pollution in the marine environment means the introduction by men and women, directly or indirectly, of substances or energy into the marine environment that cause harm to living resources and marine life, hazards to human health, hindrance to marine activities, and it singles out fishing, which of course is linked to the issues we've just discussed, and other legitimate uses of the sea. So with that definition, it seems obvious that yes, carbon emissions are considered pollution. The next point then is to say, well, if we have those points of potential regime interlinkages, if UNCLOS does not only provide a very narrow view of the marine environment, if it allows to bring the climate regime in, how does it do so? And I think very important is to remind ourselves of Article 197, which talks about cooperation. States shall cooperate on a global and or regional basis, directly or through competent international organizations, other treaty regimes, IPCC, in formulating and elaborating international rules, standards, and recommended practices and procedures. So that points to the fact that UNCLOS is rather well equipped in being open to benefit from cross-fertilization outside of the marine environmental regime. Let's have a look at, very briefly, Articles 207 and 212, and they talk about, in specific, pollution from land-based sources, and as we know, climate change is mainly a land-based source problem, and also, of course, a problem of our atmosphere. So pollution from or through the atmosphere covered by those two articles. And interesting here again, the obligation is that states shall adopt laws to prevent and reduce those pollutions. And also, again, strengthening this duty to cooperate, to say, well, through those competent international organizations or diplomatic conferences, you have to work on developing those standards, those rules, and recommended practices. So that, I think, gives us hope. What also gives us hope that the courts and tribunals have built on that and have really made it clear, hammered it home, that the duty to cooperate is one of those fundamental principles. And together with those articles I just mentioned, the duty to cooperate does not only mean within UNCLOS. It opens the door to regime interaction with, in this case, the climate regime. So let's have a look at the climate regime. If we look at the goal of the UNFCCC, the Global Convention on Climate Change, the idea is to achieve stabilization of greenhouse gas concentrations, to avoid dangerous interference with the climate system, and also to allow for ecosystems to adapt naturally to those changes that nonetheless happen. So we can already see, as you've heard from my two colleagues, that that's not what is happening at the moment. We are not giving the ecosystems the time and the space to adapt naturally to those circumstances. Moving on to Paris, which, as I'm sure most of you will know, has adopted this temperature target in saying that we have to hold the increase in global temperatures well below 2 degrees, above pre-industrial levels, and pursue efforts to limit the temperature increase to even 1.5 degrees. An interesting point here is not only that we seem to be failing big time, only if you're very optimistic you will believe that it is relatively easy to achieve those targets. But from an ocean's perspective, those targets are too lax. They're not strict enough. So a lot of marine environmental scientists tell us that the 2 degrees target definitely is way too high, and we can see what's happening at the moment to our oceans with only 1.1, 1.2 degrees of warming, dramatic impacts. And even the 1.5 degree target is still too high. So we should push for even more strict temperature, lower temperature targets than what we have agreed on in Paris, which was celebrated as a huge success. You might remember those pictures of standing ovations, and good on the French team for hammering out that agreement, which has a lot of benefits and has pushed the regime forward. But if you look at the science from marine environmentalists, not good enough. Also interesting is that when you look at what all states parties have to do under the UNFCCC, they do have to, they shall promote and cooperate in the conservation and enhancement of sinks and reservoirs. And here the oceans are mentioned. It is good that the oceans are mentioned. They are mentioned in a rather managerial way, like focusing on the ocean as a carbon sink, not talking about the ocean ecosystems. And that has been criticized. What did Paris do? Did Paris build on the new science that tells us the oceans are so important for the climate system and vice versa? I think it has failed to do so, and it will be interesting to hear from anybody who was in Paris if they are participating in today's session, why they think that happened. But it failed to do the same what it did to forestry to the ocean. Again, telling us that, well, the climate regime is mainly a terrestrial regime. It does not truly incorporate this ocean climate complex into the agreement. So a failed opportunity, but it also mentions Article 4.1 of the convention, so at least it's not going 2 steps backwards, but it should have gone a few more steps forward, in my opinion. How do we address those 2 crises better with the help of international law? And here I put a lot of hope in the NDCs. They are the cornerstone of the Paris Agreement. And because of how those 2 regimes interact, I truly believe that the NDCs are the way forward in getting climate action done with the oceans in mind, with this ocean climate nexus right in the center of the focus, at least for the countries where it is of such importance, like in the Pacific. So the idea is to slowly but surely move away from a purely adaptive approach of using the ocean as a sink and trying to prevent the erosion of coastal areas, for example, by saying, okay, how can we include mitigation strategies, seagrass, the blue economy into those NDCs? And New Zealand is no exception here. If you look at the Climate Change Commission advice, there's barely anything on the ocean, and that's an island nation. So I think a lot more work needs to be done, and I also think that the law is actually not a hurdle. As we've seen, there are options to connect those 2 regimes. Also very important to note some of the initiatives that have happened. Fiji pushed for this ocean pathway, trying to get the UNFCCC to focus more on the ocean. Madrid, COP25, was coined the Blue COP because it asked the subsidiary body for scientific and technological advice to kickstart this dialogue to say, okay, how can we connect those 2 challenges, the problems better, and address them within the climate regime? And a lot of hope is put on Glasgow in pushing this idea further, integrating the ocean climate nexus into the climate regime. And just very briefly, similar things have happened under UNCLOS. I would argue that because of the way those 2 regimes work, the climate regime is actually more apt in pushing for common action because of its COP system, for example. But the last slide, my concluding remarks. Yes, UNCLOS does provide a framework of obligations that can be linked to climate change. It has those general obligations, and in addition, the obligation to cooperate not only within the system itself, but looking outside, cooperating with international institutions, other agreements. I think there's a huge opportunity. UNFCCC in Paris more focused on the terrestrial environment, terrestrial emissions, not so much looking into the marine environment yet, but because of the NDCs, this rather flexible mechanism, I am still very hopeful that as science moves on, the law and the policy will slowly catch up. And as I said, also the mechanism for collective action much stronger in the climate regime. And I don't know why I didn't manage to make it on the slide, but I would also like to add that I think the UNCLOS dispute settlement mechanism might be a very interesting point to also look into climate change issues, which we don't have in the climate regime, but because of the linkages, there might be a way to do so. So thank you.